Good morning and welcome. My name is Melissa Jagelski, and I'm a second-year law student at the Alexander Blewett School of Law. Thank you, Dean Gagliardi, for the introduction. And on behalf of the Montana Law Review, I would like to thank the Montana State Bar and the Montana Supreme Court for allowing me to introduce this case before you today. We are here today to listen to the oral argument in the case Jason O'Neill versus Governor Gianforte. This case is about Montana's constitutional right to know, which provides public access to government documents, and whether the government can withhold certain documents under a broad privilege. The right to know is contained within Montana's state constitution. It states, "No person shall be deprived of the right to examine documents or to observe the deliberations of all public bodies or agencies of state government and its subdivisions, except in cases in which the demand of privacy clearly exceeds the merits of public disclosure." There is a tension between the right to know and the government's ability to withhold documents from public view. Here, the government is asking the court to recognize an executive communications privilege or a deliberative process privilege to withhold documents. When the delegates crafted the Montana Constitution in 1972 and included the right to know provision, they declared a presumption that the government documents are available to the public. Historically, courts have liberally construed the right to know, thus tipping the scale in favor of public disclosure. The government bears the burden of proof to show why withholding documents is necessary. If the government meets this burden of proof, the court may tip the scale in its favor, outweighing the right to know and keeping the documents private. Today, I'm going to share the factual background giving rise to the case, the legal issues before the court, and a preview of what the parties may argue. At the trial level, the plaintiff was Jason O'Neill. I will refer to him as O'Neill. The defendant was Governor Gianforte, and I will refer to him as the governor. The facts giving rise to this case are as follows. After the 2021 legislative session, O'Neill requested agency bill monitoring forms from the governor's office. Agency bill monitoring forms, or ABMs for short, contain advice from executive agency staff to the governor. ABMs advise the governor on whether to sign or veto pending bills. The governor's office denied O'Neill's request for these documents. He asserted the ABMs and related communications were entirely privileged. O'Neill contested the governor's decision to withhold the documents. He asserted that Montana's constitutional right to know requires disclosure. O'Neill requested the governor's office provide ABMs through redaction or a privilege log. The governor again asserted the ABMs were privileged in their entirety. In his letter, the governor drew parallels to executive and deliberative process privilege. O'Neill then filed a lawsuit to compel the governor to produce responsive documents. Both O'Neill and the governor argued to the district court that these issues could be decided as a matter of law without any further fact development through a motion for summary judgment. On December 14th, 2022, the district court granted O'Neill's motion in part and denied the governor's motion in full. The district court ordered the governor provide the responsive documents. It also ordered the governor produce a privilege log for an in-camera review so that it could examine the degree to which the documents were covered by attorney-client privilege. An in-camera review means the documents will be examined by a judge. The district court further held, as a matter of law, there is no form of executive privilege as a separate privilege in Montana. The district court reasoned that because the framers of the Montana Constitution did not clearly indicate the executive or deliberative process privilege, that they cannot be considered exceptions to the right to know. Further, because the executive privilege and deliberative process privilege did not pre-exist the Montana Constitution, the district court reasoned it is not clearly indicated the framers even knew of executive privilege, let alone intended it to survive Montana's constitutional enactment. However, the district court did explain that attorney-client privilege is an exception to the right to know that the framers clearly indicated. Following the district court's order, a Montana executive agency attorney contacted the governor's office with personal knowledge of the historical context establishing how ABMs originated and how they were internally used. After hearing from that attorney, the governor filed a motion for relief from the district court's order based on newly discovered evidence. The district court denied the governor's motion and certified its summary judgment order as final. The governor appealed the district court's order, making him the appellant of this case and O'Neill the appellee. That brings us to the legal issues on appeal today. The question today is whether ABMs and related communications between executive agencies and the governor are subject to public disclosure under Montana's constitutional right to know, or if they are entirely privileged under executive privilege or deliberative process privilege. Substantively, you may hear discussion about three issues: what the Montana state constitutional framers intended the scope of the right to know to be, whether executive privilege or deliberative process privilege is necessary for the integrity of government, and whether executive privilege or deliberative process privilege is deeply rooted in the American legal system. Regarding the framers' intent, you may hear the parties focus on Nelson versus City of Billings. In Nelson, the court cited constitutional convention deliberations, which explained that the purpose of the provision was to presume an openness of government in order to combat the government's power. Nelson also determined that the delegates acknowledged instances unrelated to privacy concerns in which the right to know would not apply, including when necessary for the integrity of government. Further, Nelson established the convention deliberations clearly indicate that the framers did not intend the right to know to abolish, supersede, or alter pre-existing privileges that carry forward essential components of the legal system. The governor may argue that the framers tasked the courts with refining exceptions rooted in common law and necessary for the integrity of government. Conversely, O'Neill may argue ABMs are precisely the type of document the framers intended fall within the right to know provision. As to whether an executive privilege or deliberative process privilege is deeply rooted in the American legal system, the governor may argue there is a vast historical support for executive privilege and compare Montana's right to know to other states' public access laws. On the other hand, you may hear O'Neill argue Montana's constitutional right to know cannot be compared to other state constitutions or statutes because other states' provisions do not inform what the Montana framers intended. O'Neill may argue executive privilege and deliberative process privilege did not pre-exist the Montana Constitution and thus cannot be considered exceptions to the right to know. Regarding whether an executive privilege or deliberative process privilege is necessary for the integrity of government, the governor may argue that he relies on the advice contained within the ABMs to fulfill his constitutional duties, including when to exercise his veto power. The governor may also present policy arguments for keeping the documents private and privileged. He may argue the reasons the court recognized a judicial deliberations privilege as an exception to the right to know in the case McLaughlin versus Montana State Legislature are the same reasons why a deliberative process privilege should be recognized here. In McLaughlin, the court determined that a Montana court is protected from public observation when engaged in private judicial deliberations prescribed by Montana's Constitution. Specifically, documents related to judicial deliberations are not allowed to become public because such public exposure would erode the ability of the courts to do their job effectively. In short, the governor may argue, just as the judicial branch finds it necessary to keep their deliberations private, keeping executive deliberations private is equally necessary for the executive branch. You may hear O'Neill argue that an executive privilege is not necessary for the integrity of government. Simply put, O'Neill may maintain the framers' view that transparency breeds confidence in the government and enhances popular sovereignty. Finally, the governor may propose the executive branch will not go unchecked if an executive privilege is established in Montana. He may suggest three safeguards. First, that the privilege only applies to a narrow class of pre-decisional and deliberation documents. Second, that the privilege will always be subject to review. And third, a court can order production of the privileged documents upon a showing of sufficient need. The court may also decide two related questions. First, whether the governor timely raised his privilege claims to meet his burden of proof, and second, whether the attorney's declaration should be stricken from the record. In this oral argument, you will first hear from the attorney who is representing Governor Gianforte. You will then hear from the attorney who is representing Jason O'Neill. Again, I would like to thank the Montana State Bar and the Montana Supreme Court for allowing me to present this case before you all today. I look forward to hearing the arguments.
Please be seated. Good morning, everyone. Welcome to this morning's session of the Montana Supreme Court. We're pleased to be here this morning. I'm Justice Beth Baker. I'm sitting in this morning for Chief Justice Mike McGrath. Chief Justice McGrath asked me to convey his regrets to all of you for not being here today. He suffered a detached retina a couple of days ago, and the good news is was successfully reattached and he's at home resting, but he's under doctor's orders to lay low. So I want to thank Judge Leslie Halligan of the 4th Judicial District for agreeing on short notice to sit in for the Chief Justice. And before we begin, I also want to thank the State Bar of Montana for including the court in its State Bar annual meeting schedule and having us here today. It's always a pleasure for us to participate and to be able to bring the court to other communities. I also want to thank Dean Elaine Gagliardi and the law school for providing the introduction. And I want to thank all the people who were involved in getting the logistics of this set up today. It's not easy. I'd like to introduce the members of the court. To your far right is Justice Jim Rice, Justice Jim Shea, Justice Ingrid Gustafson. To my immediate right, Judge Leslie Halligan, and Justice Dirk Sandifer. And I am hoping we have Justice Lori McKinnon on Zoom. Justice McKinnon, are you there? Not sure. The technology was still a little bit delayed, but perhaps she'll chime in at some point. And if not, we are also live streaming today, and Justice McKinnon will be participating in the case. So we'll hope to have her on board here shortly. All right, so we'll begin. This is cause number 23-0555, Jason O'Neill versus Greg Gianforte in his official capacity as governor of Montana. Are counsel ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Mr. Schoengert.
Good morning, and may it please the court. Dale Schoengert for the governor. I'd like to reserve 10 minutes for rebuttal, if I may. To make the best decision possible on whether to sign, veto, or propose amendments to legislation, the governor needs robust, unfiltered, and sometimes harsh criticism from career agency staff about those legislative proposals. But if those discussions aren't privileged, staff simply won't criticize those proposals or play devil's advocate for fear of being taken out of context, misunderstood, or subject to legislative retaliation. That is ultimately to the public's detriment because it impedes the governor's ability to make the best decision possible on whether to sign or veto a bill. The court should recognize that qualified executive privilege protecting pre-decisional deliberations about whether to sign or veto legislation for 3 reasons. First, it's rooted in Montana's constitutional structure, the American legal tradition, and the constitutionally required separation of powers. Second, the privilege is necessary for a well-functioning executive branch, just as similar privileges are necessary for a well-functioning judiciary and legislative branch. Third, it's established as a matter of law and of human nature The staff simply won't engage in unfiltered discussion about legislative proposals if those communications are publicly available where they may be misunderstood or taken out of context before a final decision is made. As the California Supreme Court put it, if the governor and the public are entitled to exactly the same information, it's likely neither will receive it. For these reasons, every single federal and state court of last resort presented with this question has recognized these principles and recognized executive privilege. I think those are nearly 20 cases to date. The right to know is undoubtedly important. It's fundamental. The presumption is that all documents in the government's possession are subject to disclosure. And that we certainly recognize that, and the governor recognized the importance of the right. In fact, the governor worked with the legislature to pass a bill to house all public document requests for government agencies or for executive agencies in the Office of Public Information Requests. That streamlined the process for the public. It's made it easier to submit requests. They can do it online. It's made it predictable, the predictable timeframe. And the branch is looking at making those documents more publicly available, even potentially on a website. So it's undoubtedly important. But as this court said in Nelson, it's not absolute. There are important exceptions that the delegates recognized when they were debating Article 9, Article 2, Section 9. And the delegates were clear that this court would define exceptions over time in the context of specific facts. As it's done with work product exception, attorney-client privilege. It's not been presented directly to this court, but judicial deliberations. In the framework that this court discussed in Nelson is the privilege necessary for the integrity of government? And is it rooted in the common law or the American legal tradition? And the exceptions it's recognized, like work product, like attorney-client privilege, it's recognized those are necessary to provide open, frank communication that wouldn't happen without the privilege. The executive privilege fits those requirements and is rooted in these same principles.
Mr. Schoenberg, you've referenced Nelson a couple of times. And in that case, we relied on two principal reasons to recognize the attorney-client privilege. First, the clear history in the constitutional conventions and the delegates' comments of their intent to protect relationships that preceded privileges and relationships that preceded the adoption of the Constitution, specifically attorney-client and judiciary privileges. And second, we found that privilege deeply ingrained in Montana's legal landscape, at the time of the passage of the Constitution. Where do we find those similar principles for the privilege that you are asserting today?
I think, first of all, the structure of the government, the delegates were building, when they were designing the Constitution, they were explicit they wanted to build a stronger executive. They didn't want the executive to be just executive in name only. They wanted to have important functions, and whether to sign or veto legislation is one of the most important functions. And to do that, and I think it's interesting that in Article 6, Section 15, actually required agencies to give the governor information when he requested. I think that's somewhat unique provision among state constitutions. So they were clearly concerned about that. Second, there are certain privileges that I think are maybe not enunciated in court decisions pre-1972. I think executive privilege is one of those privileges, but I think judicial privilege is another one. The delegates did reference, and let me just set the table a little bit. The delegates were clear they weren't, as you noted in Nelson, they weren't drafting a statute. They didn't want to list all the exceptions. They left it to this court. But for judicial privilege, there was a brief discussion between Delegate Berg and Delegate DeHood about judicial privilege. And Delegate DeHood was concerned that it would open up deliberations. So me and my friend, for example, could attend the court's conference after the case. And they wanted that privilege. And Delegate DeHood briefly stated, we are not trying to interrupt any traditional rule with the judiciary. And of course, I believe judicial privilege exists, but it's not based on Montana law, not based on pre-1972 Montana law. That I found nothing discussing judicial privilege in pre-1972 law. And it was well established in American legal tradition, absolutely. And I think sort of case in point, and so the big case deciding executive privilege sort of officially is United States v. Nixon. And the court discussed that. It was referenced, as I'll get into a little bit later, by Chief Justice John Marshall in 1807. And every executive since Washington claimed some form of executive privilege. So it's deeply rooted in the Constitution. But so both of these both of the privileges are rooted in the separation of powers and the necessity of getting the information, having unfiltered discussion, whether it's judicial or executive, having those candid conversations that wouldn't happen absent the privilege. But for judicial privilege, when Delegate DeHood was talking about any traditional rule for the judiciary, he was talking about the American legal tradition, because there wasn't anything pre-1972 in Montana law. And case in point, because I think this is a really important question. And I was thinking about it last night and found a case that it isn't cited in the briefs, but it's in re selection of a fifth member of the Montana Districting Commission, 1999 Westlaw, it's 608661. And in that case, the issue was whether the public could attend the deliberations on whether to appoint this member to the Districting Commission. Did I give that site again? It's a Montana case, Montana Supreme Court case. It's 1999 Westlaw 608661. There wasn't another site for it. And in that case, they were discussing whether the deliberations about the fifth member of the commission would be open to the public. And Justice Nelson said yes. And he took a pretty absolute position that all deliberations, everything in the judiciary should be open to the public. Justice Leaphart, though, said, and this is the first mention of judicial privilege that I've found in Montana, said, no, there is this judicial privilege. It's important. And the case he cited for that is United States versus Nixon, the executive privilege case. For the same reason, because of course, Nixon, in that case, the Supreme Court said, look, executive privilege, like judicial privilege, is fundamental to the operation of government, and it's inextricably tied to the separation of powers. And Justice Leaphart cited that decision. He cited other decisions, all after 1972. I think there was one concurring justice in a pre-1972 decision out of Michigan. But other than that, everything was post-1972, nothing in Montana, because everybody took it for granted, right? That look, this privilege is important. It's important to the operation of government. And that's what Nixon was enunciating. And so I think, for better or worse, I think these privileges stand or fall together because they're rooted in the same constitutional footing. They serve the same purpose to allow this court to.
So if we accept that, right, that there's some sort of executive privilege, how far does the privilege go? And I mean, is it only to these forms and only pre-deliberation, or I mean, what do you envision that process for determining that as well?
Sure. So we're only asking this court to decide whether pre-decisional deliberations on whether to sign or veto legislation in these agency bill monitoring forums and related conversations is privileged. It's narrow. Could it apply to other pre-decisional deliberations? I think so, but maybe that would be decided in a different case. But it's however you slice it, it's narrow, and that's there are a couple things. It's surprising the unanimity on this issue on state and federal courts.
Well, yes, but to follow up on that question, some of the cases you cite held that the governor's schedule is protected by executive privilege, the governor's appointments calendar. Would that be the case in Montana?
I don't know that it would be the case. I think it'd be in particular facts. I think Vermont Supreme Court held that and the California Supreme Court held that. I think California made a little better case for it. Given the security issues and the other issues at issue there.
Is the governor's appointment calendar open to the public today?
I'm not sure if it is. Like I said from the beginning, the presumption is that all documents are open to the public. There are, obviously, and I think the California Supreme Court noted that there are some distinct security issues there. There are other issues about, open discussions. But I think that's what makes this case a little bit simpler than some of those other cases, because it is undisputed that the sole purpose of these agency bill monitoring forms from Governor Martz through Governor Gianforte is to provide information about whether to sign or veto a bill from agency career staff and other attorneys also in the agencies in the governor's deliberations. And so it's
So you've mentioned perhaps more specifically this deliberative process privilege and kind of likened it to executive privilege, but your arguments today sound to me like it's in the narrower focus. Do you see a difference? I think the New Mexico cases indicate that they are different. And perhaps you can speak to what then happens if the governor would assert this deliberative process privilege. What would be the process?
Sure. I think the deliberative process, so it's a little bit confusing because courts have been a little bit all over the place in describing those rights. As I see it, and I think this is definitely the majority view, deliberative process privilege is kind of a subset of executive privilege, and it can apply more broadly to interagency deliberations. That is not what we're claiming here. We are claiming executive privilege, and some courts, I think the New Mexico court, some courts have sort of used those terms interchangeably.
So is it your intention that we use them interchangeably?
No, I mean, I think I think you could. I mean, I think other courts have, but I think the confusion is it's executive privilege for the governor's deliberations. But in Ray Sealed case, the DC Circuit discussed that, and Washington Supreme Court discussed the distinction in Freedom Foundation versus Grigori. And here, the district court said, the analysis is really the same. But the executive privilege we're claiming, I think, is much more narrow than the broader.
And it's pre-decision, is that correct?
Correct.
So if this is granted, or if the court finds that that's appropriate, and then what happens after the decision? Is that then open to public dissemination? And if so, does that not have the same chilling effect that you've described?
It would not be open to the public because of the same chilling effect that it would have. And that's as far as I can tell, the unanimous view among courts, and just like judicial decisions, right? I mean, and that's the
So
comparison.
is that not different though than this deliberative process privilege? So you're just saying that it is perhaps ramped up to an executive privilege where none of that information would be subject to in-camera review or dissemination?
It could be subject to in-camera review, and I want to follow up on Justice Gustafson's question because those are related. So the process, and there has been a pretty, not unanimous, but pretty clear process laid out and how to deal with these issues. The first step is the governor has the burden to assert the privilege, to show, assert the application and scope of the privilege. Now, that the court could require privilege log in doing that. Here, I mean, given the fact that all the documents are served the exact same purpose, I don't think that would serve much purpose, but you could, just like any other privilege, the district court could ferret that out. If the court determines that privilege has been properly asserted, then the burden moves to the requester to show sufficient need, because it is a qualified privilege. And the United States Supreme Court in US v. Nixon discussed this process. Vermont Supreme Court in the Killington case discussed it, and the Washington Supreme Court discussed it in Freedom Foundation v. Grigori. And then after, if the requester shows sufficient need, then it can go to the court for in-camera review to determine whether those documents fit that need. And that's really what the, United States versus Nixon, that sort of first discussed this process in the right in detail. The documents there was a criminal case, right? I mean, so the court didn't say all these documents are protected. They said, this is a really important right. It's fundamental to the operation of government. It's based on the separation of powers, but it's not absolute. And in the context of government wrongdoing, fraud, there's a criminal case. There's some examples that courts have recognized as being particularized need that would overcome the privilege. And it's kind of a similar process to work product privilege, as far as I can tell.
So what about in terms of the privilege, then you mentioned work product and attorney-client privilege. So, I mean, that privilege can obviously be breached or waived if there's a third-party participant, and we don't know what's in these AVMs. So if there is if they include a third party's input, like a lobbyist or something like that, wouldn't that waive the privilege?
I think it's still, it may be a closer call. I think it would still be the governor's deliberations. It'd be advice from the governor. We don't have that. I mean, in this case, Anita Milanovic submitted her declaration. It's Appendix 20. And she stated outright, this has been, they redesigned the form so they could not be distributed outside those directly involved in the agencies or the executive branch for those communications.
But what about, and what I'm talking about is if there was, and I recognize that it's coming from some member of the executive branch or even an attorney, but it's relaying, saying there was this input from X who is outside the executive branch, and that is included in the AVM. Doesn't that, I mean, wouldn't that fundamentally waive the privilege?
I don't know that it would waive the privilege because it's still the agency saying like, hey, here's an idea. And just because they heard it from a lobbyist I don't think that waive the privilege, because I think, this process, as the Washington Supreme Court said, there's the interest in coming up with bad ideas so you can get to the really good ones, right? And so
I would just, not to interrupt, but
Yeah.
Would it subject to, I mean, some sort of redaction? I mean, if
sure.
if a third party is having input to the governor's deliberations, who is outside the executive branch, whether it's a lobbyist or his neighbor, it seems to me that, the communications that are directly between the staff member or the agency counsel and the governor could be redacted, but the public would have a right to know that there was somebody from outside the executive branch offering input to the decision-making process.
In that context, I could see that rationale for sure. And I think that's something that the district court could ferret out, with kind of figuring out what we're dealing with. And that would make some sense.
So walk me through that process, counsel. You're suggesting a pre-deliberative, narrow privilege for the governor to receive information, but that is subject to judicial review and in-camera inspection. And I'm wondering, in the heat of a legislative session and you're coming down to the end and there's these hundreds of bills that are pending and all these requests are being made, challenging and wanting to get the information coming to the governor, these are all going to be handled by the courts in some short time frame, or how does that play out?
Well, I think that's part of the problem. I mean, usually this request, I think, was made after the legislative session. And that's, I think, typical. I don't know that there's ever been a request during the session. I think that would implicate what Court Jensen mentioned, that I frankly, I mean, I can't believe I hadn't thought of it, that this could entail legislators being pretty upset about criticism. So I think during the session, it's especially important that those are protected. But even the process of determining, fulfilling public records requests takes some time. And I was in charge of this for a little bit when I was at the Attorney General's office, and so I have some context. It is unbelievable the amount of requests that come in, and they take some time to process. And so that's kind of what we've got normally. But I do think, that's part of the reason for establishing this agency is to expedite that process. And I mean, if there's really a need, I mean, we can always ask for expedited review from the
So
court.
as a practical matter, the judicial review would come at the post-decisional stage, it sounds like to you.
Correct. And I think that's typically when people are going to be requesting the documents as a practical matter.
When under your proposal, they would be public anyway,
No, they would not be public.
even after the decision?
Correct. And yeah, after the decision, because that would chill the communication. If everybody knew, the decision is certainly public, just like this court's decision is public, but the communications, the deliberations, those stay privileged. And that's, courts have roundly concluded that that's important for the purpose of the privilege itself.
What about then as far as the destruction of these ABMs? I mean, that has occurred since the Martz administration. I understand that was every administration's practice. I mean, would there be now, I mean, you can't disclose something or have in-camera review of something that's been destroyed. So would it be the practice now to preserve them, just classified or?
I think it could, and to be clear, my understanding is that they were destroyed at the end of the administration. So somebody could have the entire administration to ask for those documents. They traditionally been destroyed because I assume because they've been considered privileged. If the court tells us not to, we of course will abide by that. But there's typically a pretty long tail for when people can ask for those documents. And I'd like to talk a little bit about just sort of the foundation again. So, this court, there have been a couple cases, you've probably seen them. Nixon was one, I think, maybe the California Supreme Court's decision was another, where advocates have said, this is such a big separation of powers issue that the courts can't even decide it. No, we always didn't make that decision, that argument here. I think it'd be a bad argument. And if I had made it, you could respond with one line. It is emphatically the province and duty of the judicial department to say what the law is. Marbury versus Madison, 1803, foundational principle. And I think the founders were at least implicitly recognizing that when they designed our Constitution to put this in the courts, within the court's purview. Now, that comes though with an important corollary. And John Marshall discussed that 4 years later in United States versus Burr, where we recognize when the court doesn't operate against a private, against the executive as it would anybody else. And that's based on the separation of powers. And that was in John Marshall was recognizing an early executive privilege. And that's what courts have pointed to, not only executives' practice of that, but also his early recognition of that principle.
So
And-
counsel, didn't Nixon involve the requests between branches? And here we have the request from the public and a very strong constitutional provision with regard to the public's right to know. How does this request square with the request between branches? Obviously, that dealt more with the separation of powers.
And I think that was a subpoena, and it was in the context of the criminal case. Courts have not drawn a distinction because I think the principles that underlie them are the same. The court's still requiring the executive branch.
So you don't
to-
see a difference
I don't-
between branch to branch requests versus public requests? of
I
the
don't,
branch?
I don't see a difference because they're enforced through the court. And that's kind of what I think Marshall is getting at. It's like the court's got to tread sensitively here because there is a separation of powers principle.
Well, counsel, to follow up on that, I'm having a hard time understanding how separation of powers is implicated here as a threshold matter of law. As you rely on Nixon, which is a very significant case, the focus there in large part was the tension between the president's need for confidentiality of internal communications with advisors regarding presidential discretion and the needs of the criminal justice system. But to follow up to Judge Halligan's question, yes, it's the public making a request, but more fundamentally, you have a co-equal express constitutional right of the public to know. And the approach that Nixon took that I saw was that the Supreme Court recognized both the president's privilege interest as an important constitutional interest and the needs of the criminal justice system, but then recognized that those needed to be balanced. And the focus was on to what extent is respecting one over the other going to diminish the other significantly, and how do you find that balance? But I don't see how the separation of powers here is implicated when what we're talking about is the tension between the governor's need and privilege, which I think there needs to be some recognition of that, as there was in Nixon, but with this co-equal express provision of the Constitution.
I think a couple of points on that, Justice Sandifer. The tension comes in, and I think the Washington Supreme Court's decision in Freedom Foundation versus Grigori was helpful to me in working through that issue. And there, the court said the separation of powers is implicated not only when a branch is arrogating power to itself, but also when the constitutional authority of another branch is impaired. And I think that's what we have here. We have the governor's constitutional authority under Article 6, Section 10 to sign, veto, or propose amendments to legislation. And that is, I think that is the competing constitutional
And
interest.
how is that being infringed or competed with by the judicial branch and the legislative branch in this context? Because that's what separation of powers is about.
Because and I think that goes back to Marbury versus Madison, the critical power of judicial review, which is firmly established, but it comes with some caveats that the court it would be enforcing that right against the executive branch.
We can't recognize that extent of that. I mean, if that was a valid observation of law, then anytime that the court interprets the constitutionality of a legislative enactment or an executive branch action in accordance with applicable constitutional law, that somehow implicates separation of powers. That's the function. That's what Marbury Madison is about. That's the function of the court as charged by the founders of the federal and the state constitution.
No doubt about it. And I fully agree. But every time the court does make a decision, that impacts the other branches, it does implicate the separation of powers. Now, it doesn't mean it violates it. The court has to do its job, and it's doing that job. It fully exercises the power of judicial review. But when the court's ordering a coordinate branch to turn over documents, it is acting. And let me take it from just another angle. If you don't like that argument, I've got another.
No, I don't.
Fair enough. The other, I think, issue that comes in is where, so the courts recognize that there is judicial privilege. I think that's absolutely correct. If it were challenged, I'd be among first in line to defend it. The district court, in fact, the district court in this case has also recognized the legislative, a different judge, same court, legislative privilege. It would be odd as a matter of constitutional interpretation if the delegates intended for two branches to have a privilege for the same reasons or similar reasons, but the third not to.
Let me just follow up on that, on the legislative privilege issue. A lot of bills also the legislature gets a memo from its own staff about legal advice on the bill and whether it's likely to generate litigation and what the constitutional implications might be. Presently, those are made public during the session. How would your argument apply if the legislature claims privilege for those kinds of advisory notes from its own staff?
I think the legislative privilege has two roots: speech and debate clause and the separation of powers. And that's what the district court recently recognized. And I think that comports with cases around the country. I think that interest is applied differently to the legislature when it's because I think with the courts, I think it's consistent with this court's precedent and others, is that the governor's authority to sign or veto legislation is distinct. It's a critical moment, and everybody knows what the ultimate decision is. And so I don't know that those would I think the judicial privilege and the executive privilege have been tied pretty directly. The legislative privilege is a little different because it's typically rooted in the speech and debate clause. But I think so I think there are important distinctions that don't apply, that apply to the other two, but don't apply to the legislature. But it would be, I think,
Let's follow up on your comment, though. I think I do like that argument, in contrast to your earlier one. I think that's a valid point, that the justification that was actually discussed in the Constitutional Convention by Delegate DeHood and others, that the judicial, particularly the Supreme Court case-based deliberations, need to be confidential and free from public scrutiny. And Nixon recognizes, and the Supreme Court through Nixon has recognized for the same policy justifications, that there should be some limited privilege in the executive branch. And I think you make a valid point, but then where do you divide that line, and how do you bring that in balance in regard to the subject matter that's at issue in this case?
I think that it helps that these are very narrow, and it is the parallel is that when the court's deciding cases, it's acting pursuant to its constitutional duty and authority. When the governor's determining whether to veto or sign or propose amendments to legislation, he's acting in accordance with his constitutional duty and obligation under Article 6, Section 10. And everybody knows what the ultimate decision in both cases is. Everybody knows whether the governor signed or vetoed the legislation or whether he proposed amendments. Everybody knows what this court's decision is. It's getting to that point. It's those internal sort of devil's advocacy when you're working through the decision that's protected. And in that regard, I mean, this privilege isn't ultimately for the governor. I mean, governor's got thick skin, as every other governor has, as probably every statewide elected official does. It's for the staff so that he receives that unfiltered information from the staff.
But there is a fundamental distinction between the judicial deliberations and the deliberations we're talking about in terms of whether to sign or veto a bill. I mean, for one thing, there is absolutely no mystery about what the record a judicial decision is based upon. I mean, and with, exceptions, if there's something under seal because it involves juveniles or something like that, the record is absolutely clear. I mean, one of the issues we have that's been raised is the declaration of Mr. Jensen, because they think it shouldn't be part of the record. And so everybody knows what a judicial decision is based upon. And it's not just an up or down vote. I mean, sometimes I wish it could be, but I mean, the judicial opinions explain the deliberative process. I mean, the analysis, everything that went into it, and it doesn't go outside the record. And so isn't that a fundamental distinction between what we're talking about here?
I think it's pretty parallel, actually, because everybody knows the information, like Justice Baker said, everything's in the legislative record too on proposed legislation. The very narrow purpose of these forms is just to inform the governor whether he should sign or veto, acknowledge pitfalls, and maybe the soft underbelly of legislation, and propose alternatives. It's not an up or down either. I mean, that's the other component, is that they're working through potential alternatives.
But what the public sees is, and I know that there can be veto statements and things like that, but by and large, what the public is seeing is either the bill got signed or the bill got vetoed. And that's the difference when a court issues an opinion. It basically lays out why the decision was made, which is contained in these ABMs to a great extent, but not disclosed.
Well, it's contained partly in the ABMs. I mean, I think the legislator and the governor does, when he vetoes, he's actually constitutionally required to say why. And so, but the court's internal deliberations among justices, memos you may get from clerks, that sort of hashing through a decision, I think that's not subject to public disclosure. It shouldn't be public disclosure because it would chill that speech. And I think that's what the ABMs are doing. If I can reserve the remainder of my time for rebuttal. Thank you.
Thank you.
Ms. Van Cleef?
Good morning. May it please the court. Constance Van Clay on behalf of plaintiff and appellee Jason O'Neill. Montana's constitutional right to know applies and has always applied with equal force to the governor and to other members of the executive branch. Transparency and open government are the status quo in Montana. And it's against this backdrop that we should see the governor's request for what it is. It's a novel request to create a broad, never before recognized exception to our fundamental constitutional right to know. It's an exception that would swallow the rule, and it's an exception that would apply to the governor because of, not in spite of, but because of his office, his political power, his position of public trust. And
Well, excuse me,
ultimate-
counsel, is it your position then? Is that an absolute position that there should be no recognized executive privilege in regard to communications that go to the governor's thought process?
Yes, Your Honor, no executive privilege as such. Now, there may be some documents that are housed within the executive branch that may otherwise be outside the scope of the constitutional right to know. But
How would you define those? What kinds of documents would be not subject to public scrutiny?
first, documents where there are significant privacy interests that clearly outweigh the interests of the public in disclosure. And then I think we can look at Nelson and consistent with the convention transcript. And there are documents that are recognized that are kind of core to the integrity of government. And what the delegates were talking about, specifically the example that was used at the convention, were documents about that would relate to purchasing property before that property was purchased. Because if that information was subject to disclosure, it would interfere with the ability of government to get that property at the best price possible. We want to allow the government, like anybody else, to engage in a competitive business process. So there you see a direct interference with the ability of government to operate if these specific documents are disclosed at this specific time. But executive privilege is fundamentally different from that. And the reason for that is because it has no limiting principle. And we can look here to the record, to the information request, and to the responses to it to get an idea of what exactly this executive privilege looks like. A citizen asked for documents for government forms, and the governor did not disagree that these government forms fall within the scope of the constitutional right to know, that they fall within the scope of the statutes, the Open Records Act, and yet the governor nonetheless said simply no. And not only that, but I don't need to give you a privilege log. I don't need to give you redacted documents or a reasoned explanation. I don't even need to give you a blank version of this government form. And that's what executive privilege looks like.
But counsel, I think that's too narrow of a look at this, because that may indeed be how the case is resolved at the bottom line once we decide whether and to what extent there may be a cognizable executive privilege that's constitutionally permissible. But how that applies to the particular documents at issue in the case is the end stage application of this, and doesn't solve the question or address your point that there should be no executive privilege whatsoever recognized by this court under the Constitution.
So I have kind of two responses to that. And the first is, as this court has been clear, when government seeks to establish an exception to the constitutional right to know, government bears the burden. And that would start with a clear definition of what this privilege purportedly is, applied to the facts of this case. We still don't have that.
Well,
Now,
I
this-
agree with you about that, but what I'm hearing you say is there should be no privilege.
And I think and the reason for that is the justification for this privilege. So the governor presents two justifications for this privilege. The first is that other jurisdictions have done this. But not one of those jurisdictions shares our constitutional right to know. And requests from citizens for information are fundamentally different than
Well,
the interbranch conflicts that come up in many of those cases.
It's
And the
true
sec-
that these other jurisdictions don't have Montana's constitution. And I don't disagree with your argument that we have to decide this case based upon Montana law and the Montana Constitution, but these cases have been numerous throughout the country. They've all been decided in favor of the executive. And even though they're applying a different law, they seem to stand for the factual reality that a governor needs to have this place of confidentiality to receive information to make decisions that only the governor can make. So how does Montana law accommodate what appears to be an undisputed factual reality about how the executive has to operate?
I think we should start with looking at the purposes that are affected in those jurisdictions when they have recognized either executive or deliberative process privilege. And there are two. There's this separation of powers argument, and then there's this claim that it's essential for a governor to get the right information. So I'd like to talk about both of those purposes to see whether they hold up in Montana, and they do not. Separation of powers simply should not be implicated here. And it would not be if there is no executive privilege, because the right to know is self-executing. It was only because the governor denied a request for information that is within the constitutional right to know that the judiciary became involved in the first place. Ordinarily, this is a dispute between citizen and executive. And it is not an interbranch conflict. And so those other jurisdictions, this is another reason why other jurisdictions that don't have a constitutional right to information are necessarily different. Now, I want to talk about this purpose.
Okay, so the right to know, you said, is self-executing, but it's not absolute. And the delegates clearly intended that the courts would be involved. Where do you find in the Constitution support for treating differently or giving certain privileges to the judicial branch deliberations, but not the executive branch, without room for that case-by-case kind of analysis?
Yes, Your Honor. And I want to say that I do think it is appropriate for the court to resolve the question of whether or not executive privilege exists or should be created in the first instance. And that it is a kind of practical point that if there is no executive privilege, there will be no need for judicial involvement. As for treating judicial deliberations differently than executive communications, first, the judicial deliberations privilege is narrow. At no point has the court said that everything that we touch that may factor into how we perform our duties as judges, as justices, is outside the scope of the right to know. And in reality, that is what executive privilege looks like. This was important to me when I made a decision, and so I don't need to give it to you. And second, as discussed in Nelson, what we are looking for is we are looking for an exception that is ingrained into the legal landscape of Montana at the time of the Constitution's ratification.
Well,
And-
the Constitution was ratified in 1972, though, and US versus Nixon wasn't decided until 1974. So, I mean, prior to that, I mean, it's fair to say, I mean, executive privilege wouldn't have really been on their radar screen when they were discussing this at the Constitutional Convention.
Your Honor, what is clear is that the framers of the Constitution wanted to expand the categories of information to make all information presumptively open to the people. And the framers did. Nonetheless, judicial deliberations were on the framers' radar. They discussed that during the convention. And they pointed out that they did not want to interfere with any traditional rule of procedure as it applies to the judiciary. They recognize that the judiciary has had its way of doing things. And so there's this historical backdrop that informs the Constitution in 1972. And importantly, the legislature has passed laws that are consistent with that understanding. Judicial deliberations relating to adversarial proceedings are confidential information under the Open Records Act today. And so you have a through line of recognizing a judicial deliberations privilege. There's nothing like that with regard to executive privilege. There's nothing in the revised codes of
But
Montana.
counsel, you're talking about apples and oranges. What the Open Meeting Act and the statutes the legislature says about that is one thing, but we're talking about what the Constitution says. The Constitution doesn't say anything about expressly or implicitly from its language, the confidentiality of judicial deliberative proceedings. So by your logic, then we shouldn't have that either here.
No, Your Honor, we don't disagree with Nelson, and we think we can apply the framework in Nelson here. It supports Mr. O'Neill's position. What these later enactments show is that, consistent with the convention transcripts, that a judicial deliberations privilege is ingrained into Montana's legal landscape, that it's baked into the Constitution. And there's no evidence for a similar executive privilege in Montana.
Well, let me respond to that. I mean, I think you make that's a valid point as it relates to Supreme Court deliberations. But the fact that the delegates discussed that particularly in passing and some other things, that wasn't an exclusive list of concepts that they viewed as the only things that the public right to know didn't apply. And as they point out on this side, the governor points out that Chairman DeHood of the Civil Rights Committee pointed out that we don't want to mess around with existing legal privileges that are well settled. And so I don't understand that how that point on its own can get you over the hump here.
Because there isn't an existing legal privilege for executive privilege. There isn't evidence of that predating the 1972 Constitution in Montana. What we have, again, this assemblage of extra-jurisdictional sources, and only one of those decisions that were cited in the governor's brief, California has a constitutional right to transparency. And that constitutional right to transparency is different because it was ratified after the decision recognizing executive privilege in California and incorporated pre-existing privileges.
Well, let me get your reaction to this. In Nixon, the Supreme Court, in recognizing, not defining yet its extent and parameters, but in recognizing the legitimacy of some extent of executive privilege, recognized that the privilege derives from the supremacy of each branch of government within its assigned area of constitutional duties, And we're talking about protection of the, and they use the language, decision-making process. And it flows from the nature of the enumerated powers and the protection of the confidentiality of presidential communications that have similar underpinnings. Now, that is a constitutional analysis that would fit equally to the Montana Constitution, regardless of the express public right to know, and then leave the question is, how do you balance those? Do you disagree with that?
I do disagree with that, Your Honor. I don't think that we can disregard the constitutional right to know when we are looking at whether or not this privilege should exist.
I'm not saying that. I'm saying it has to be balanced, but you seem to be saying that you would disagree, and don't let me put words in your mouth, disagree with this recognition that there ought to be some privilege that the governor has here.
Your Honor, I do. And if you look at the language of Article 2, Section 9, what we have is we have a direct incompatibility between our Constitution and the reasoning that is presented in Nixon, because
How so?
Article 2, Section 9 expressly refers to the right to observe the deliberations of all public bodies. Our Constitution expects that the people of Montana can understand that decision-making is sometimes difficult, that it is messy. There is no need for secrecy in the decision-making process.
Is the
here.
governor a public body?
Your Honor,
There was some substantial discussion about what was and wasn't a public body in the language of the Civil Rights Committee before they proposed this to the Committee of the Whole.
Correct, Your Honor. And they chose the word public body because it is expansive. The idea was, should we narrow it to agencies? Should we come up with some limiting definition? And they said, no, it needs to be expansive. We want to open up government. And
how do you say, though, that when we're interpreting constitutional language, the express language of the Constitution, that a unitary constitutional officer is a public body?
Your Honor, the legislature, consistent with the framers' intent, has also defined public body to include the branches of government. This is not and the district court determined.
We're not talking about what the legislature has done. No, we're talking about how we interpret the Constitution.
In Montana, under our Constitution, the language public body is intended to, it is expansive, and there is no disagreement here. The governor does not dispute that these documents, that these government forms fall within the scope of Article 2, Section 9.
But Article 2, Section 9, I mean, it's the expanse of Article 2, Section 9 carves out the only exception is the right to privacy, and that's the only balance. But yet we have recognized that there are exceptions of privilege that are not found within the plain language of Article 2, Section 9. So, I mean, it seems like specifically for executive privilege, you want to create an absolute, but we've already recognized the attorney-client privilege, the work product privilege, there are other privileges that go beyond just individual privacy. So I'm trying to, and I'm struggling with, and I get what you're saying about that it isn't in the transcripts of the Constitutional Convention. But again, that was not something that was recognized by a court in a decision until 2 years later. So there's a rationale why they wouldn't have been talking about it. They would have been awfully prescient to be discussing executive privilege in that. But as has been recognized, I mean, it was discussed. It just hadn't been ruled upon by the courts prior to that. And so wouldn't it be, if we're looking just historically rather than actual legal precedent, I mean, it was a recognized privilege prior to the Constitutional Convention. And that's how we've found the underpinnings for judicial privilege, for work product, for attorney-client. So I'm struggling with the absolute argument based on the specific language of Article 2, Section 9.
And to be clear, even if the court declines to rule on this broad issue to decide whether or not executive privilege exists, there is a narrower path. I do think it is appropriate to resolve this issue. And I want to address that it's not just that there's no evidence in the convention transcript. It's that there is no evidence in Montana before or after. Government has functioned, and there's no indication that government has been unable to function because of our culture of transparency, because of open records.
Well, do you dispute, I mean, these ABMs have been dating back to the Martz administration when they were created, that every administration has treated them as confidential, as privileged. So it just hasn't been challenged before. I mean, there was no ruling on executive privilege before Nixon, but that didn't stop the Supreme Court from saying that it existed.
I do dispute that. And it's not supported by the record, that claim that they have been historically treated privileged. Not only are there the evidentiary issues to work through, but if you read this declaration that's being used, all it is one attorney's legal opinion declaration that says, I assumed that the constitutional right to know doesn't apply. And I think some other people did too. And that is what it is. That is not nearly strong enough evidence.
Are you familiar, just kind of, and I recognize that there's some nuances here that we have to resolve in terms of what to consider in the record. And there was the post-hearing Rule 59 and Rule 60 motions. But so I don't want to put you at a disadvantage, but are you aware of any instances where there was a request for these ABMs from the Martz administration through the current administration that they were just given?
I am not aware of any instances, but I do think that it is incredible for us to be asked to believe that no citizen has ever before asked from a governor information that would evidence the governor's deliberative process on a core executive function. And I do want to say, although there is no discussion of executive privilege, I agree, it wasn't on the framers' radar at the time. Nixon comes later. But what is clear is that just as the framers were looking at building a stronger executive branch, they were concerned about the consolidation of power with that executive. And the answer to that is accountability and transparency. The reason that it made sense to get rid of the 160 independent, quasi-independent boards and agencies under the prior constitution was because the governor is accountable, and transparency under our constitutional scheme is essential to that. And the executive committee came out with a majority report and a minority report. The minority report was adopted because it diffused power a little bit more with more independently elected executive branches. And I'd like to read from the transcript. This is at page 845. This is the introduction to the minority report that won the day, that forms the basis for our Constitution's provisions governing the executive. Government needs to be more to its constituents than efficient and economical. It needs to be responsive and responsible to the people it represents. Its responsibilities include not only the matter of protecting the public trust, it includes having the trust of the public. Public trust does not come from just a matter of confidence in the integrity of public officers, but rather it comes from knowing that public affairs are placed in the public eye. This can only occur when the activities of government are visible and when there are ways of checking what our public officials are doing.
Counsel, that's all true. But that doesn't, if that was all we had to look at here, then we don't have any privileges after 1972. And that's not the case, and that's not what they intended. we disagree about this, so let's leave that alone. Let me ask you this, if this court was to recognize along the same constitutional analysis that the Supreme Court has, that there is at least some kernel of executive privilege, how would you suggest then that we define, without conceding your main point that there shouldn't be any, how would you suggest then that we sketch out the parameters of that?
I think that if there were any privilege at all, it would have to be the governor every time would bear the burden of showing that this assertion of privilege is demonstrably connected to the governor's ability to perform a specific task. And that gets at what the framers were talking about when they were talking about these privileges that are essential to the integrity of government. With that example being purchasing property. And the governor has to explain, has to give a real reason why this is the case. And frankly, I think that that would be the same result even if we were applying some form of qualified privilege. And that's why a categorical rule is more appropriate in this instance, because if you look at what a qualified privilege is, it's a privilege that gives way in the face of a fundamental of a sufficiently important interest in the other side. Nixon is the classic example. And in Montana, we have a fundamental individual constitutional right to know. And what we have to support executive privilege is this claim that I think it would work better. I might say things differently. This is not sufficiently strong to outweigh that fundamental constitutional right.
So if we adopted that narrower focus, would this case be remanded to the district court for developing a record to give the governor an opportunity to meet that burden?
Your Honor, I don't believe so. I think that at this point, the governor has failed to meet his burden. And Nelson addresses this issue of the government's burden. The burden falls on government not only to identify the scope of the privilege, but to apply it. Nelson, we had a kind of a good faith effort by government to do that with regard to the attorney-client privilege. Privilege log was provided, over 7,000 documents were provided. And I think that under the context of this case, what we are looking for, there is, not only has the governor failed to meet his burden, but there's absolutely no way that these documents could satisfy that test of some specific showing, because we have the justification here in the record, and the justification is just generally that these documents informed my decision-making when it came to my exercise of my duties as governor. That is necessarily not sufficiently important.
Well, but there were other privileges implicated. I know we're here basically for the executive privilege argument, but I mean, there's a reason why the district court only granted partial summary judgment. I mean, there were still the issues where the district court held that it needed to conduct an in-camera review. So wouldn't that be required anyway?
Yes, an in-camera review is what will happen if the court affirms as we are asking it to do. And that is for analysis, for application of the attorney-client privilege. And we don't dispute that, that in-camera review should go forward.
So counsel, before you run out of time, you cited Babbitt, which is the Massachusetts case, which Massachusetts didn't recognize executive privilege, but did recognize some deliberative process privilege, applying only prior to the decision. I'd like to know your thoughts as to whether or not, if the court's trying to determine what the process might be, the governor, of course, has said that even after the decision is made, that information should remain confidential. I did believe that's different. And so do you think we should be looking at something like Massachusetts did, or what would your suggestion be?
I don't think that we need to look to what they did, because executive privilege is fundamentally incompatible with the Montana Constitution. But again, this gets to what are the purposes for the privilege that is asserted and do they hold up? The purposes are not sufficiently compelling to create an exception to Montana's constitutional right to know. So I don't think we need to look at whether or not they hold up, and that would be that next step.
So your position is that should a privilege be asserted, then the court should become involved, determine whether or not there is sufficient privilege or sufficient information, and then have an in-camera review.
And if there is a legitimate privilege that is asserted, that is the case. But under our Constitution, executive privilege is not a legitimate privilege. We ask that the court affirm.
Thank you. Schoengert, I think you have just short of 4 minutes.
Thank you. Just a few brief points in rebuttal. I'd like to start with this, the last point, how to sketch out the right and this specific to the facts of this case. Anita Milanovic said initially in her initial communication, now they initially thought that these were attorney-client privilege. They realized later they included broader documents, but analogized to the judicial privilege and cited the Grigori case, the Freedom Foundation case. And she described what's in the form, which is a similar form to what was used from the Bullock administration. That's where they got it. They made some tweaks to sort of limit who that was distributed to and make some other, cosmetic tweaks. But Anita Milanovic described the categories of the form exactly as the headings. If we would have been asked to produce a blank form, we would have. We were never asked in discovery or in the records request. And importantly, that declaration also asserted the reason for it, that the governor relies on these forms in his deliberations about whether to sign or veto a bill, that those were routinely done past administrations, and that he was using those in exercise of his constitutional authority.
So counsel, the issues come up and the governor hasn't asserted this issue that Justice Sandifer brought up about, is it a public body? My understanding is that, of course, over the time of the Montana government, governors often convene their staff and discussed whether or not a bill would be vetoed. That transitioned apparently in the Martz administration to a form given the volume of bills. But my sense is that the public doesn't come to those discussions, it's staffing, and that's essentially what you have in this form. Why is it that the governor has not raised that issue as a potential defense or issue?
Yeah, I was hoping I could get away without being asked that question. Because I think it's dicey, and I think Justice Sandifer said that there's a lot of discussion. In fact, that earlier case that I cited, the 1999 districting commission case, goes at length into that question. I think it is a little bit thorny. I think, as I read it, the delegates were saying, they were really concerned about, local government. And they listed sort of the public bodies that they really were focused on. Traditionally, the three branches have been considered public bodies, but I think this comes through in Nelson. It's not always, in not every context are they a public body. And for example, when the governor's in his office deliberating, nobody would suggest that he's a public body and everybody can come in and see that. So I do think it's a little bit, I don't fully understand how that should come out, or I don't fully have a position on how that debate should come out. But I accept that, and I think Delegate DeHood said this, there's a lot of semantics involved, but I don't think that any of the branches, especially the judicial and the executive branches, were considered public bodies in those instances where the exceptions apply. And that's my best view.
Now that doesn't happen, right? The governor
Correct.
meets with staff,
Absolutely.
but the public is not participating.
Absolutely. And I think that fits with that framework. We're asking for a narrow exception. The delegates left explicitly to this court to decide. The plaintiffs are departing from the traditional framework and that has longstanding legal tradition in this country, recognized in American executive privilege, and asking for a categorical exclusion of executive privilege. They're at odds with that framework. The important purposes of the executive privilege has been recognized by court after court after court. And as the United States Supreme Court said, it's beyond reasonable debate that the purposes that this privilege serves in fostering unfiltered, robust, and sometimes harsh criticism of bills.
So I asked about the Babbitt case where Massachusetts didn't recognize the executive privilege. Do you disagree with that? And if so, you seem to have a different, I guess, suggestion with regard to the deliberative process.
Yeah, the Massachusetts Babbitt's case didn't recognize deliberative process privilege. It was that process, that privilege between agencies. The governor executive wasn't involved in that case. And the Washington Supreme Court noted this in their case when they were dealing with this. I think it was Washington Supreme Court. I think it was footnote 15. Could be wrong about that, but in that case, there's a discussion of Babbitt's as it relates to, and they note the later Massachusetts Supreme Judicial Court that did recognize a form of executive privilege, but they didn't recognize deliberative process privilege, which, you know, like I said at the beginning of my remarks, that is a different privilege that we're not claiming.
Thank you.
All right, thank you.
Thank you, Your Honors.
Thank you to all counsel for an excellent hearing. We appreciate your work and thank you all again for attending today's argument. The court will take this case under advisement and issue a decision in due course with
Thank you.
explanation.